This presentation actually came out of discussions I've had with a number of people in the offshore legal and service provider world. And essentially, a lot of you are seeing domestications of formerly foreign structures, even for wholly foreign clients. And a lot of that has been CRS driven. So part of the discussion was, well, there's still a huge need for offshore legal and service providers, both in the inbound context and the outbound context, facing both for non-residents who are looking toward the U.S., as well as foreign people who are, as well as U.S. people who are looking abroad. I'll start with a little bit of a backstory here. When Tara was kind enough to invite me to speak at the presentation, I was still an international tax attorney in Miami. And I worked for a law firm there. I worked mostly in the inbound space with LATAM clients who were investing in the U.S. I subsequently got an offer I could not refuse to come join HSBC in New York instead of Miami. And part of that comes with how we do the presentations and why I need this disclaimer. When I was in a law firm, I was in a small law firm, I was my own content provider. I'd prepare everything, I'd set it up, I'd send it, I'd come speak on it. No problem whatsoever. Apparently not how things work at a bank. Apparently everything has to go to legal, and then it has to go to compliance, then it has to go to marketing, and then after marketing's done with it, it goes back to legal and compliance, and the marketing wants to look at it again. And I eventually just said, screw this, can I just put the disclaimer up and not have to deal with you guys? And they said yes. So there it is. The views are my own. They don't necessarily represent HSBC's views. Now we can get on with the presentation. And obviously this one I have to put up as well, that we're not constituting legal and tax advice. This is for informational purposes. This one I've had forever as a lawyer. So again, we're going back to this. This is the continued need for offshore legal and service providers. And just in terms of the CRS, and I know a lot of people are worried about that, I think that is going to be more of a temporary situation than a permanent one. The U.S. does have laws in place which punish U.S. tax providers who do anything to engage in tax evasion for foreign governments, foreign entities. So I think the first time a Pasquantino style case comes and hits somebody who is setting up a CRS avoidance structure, you're going to see a lot of change. But until then, there's still a great need for all the people in this room. And I broke it out in two different ways. One is for the inbound investor. One is for the non-resident alien, the non-US person who has either investments or business interests or kids who are, US facing. And we talk about the continued need for foreign legal and service providers. We also talk about what's changed under the 2017 Tax Act. The answer to that is not much on the inbound side, but on the outbound side, things have changed dramatically. And I think this is an opportunity for people who are mindful of this and looking for the right opportunities. And I talk about how the 2017 Tax Act has created difficulties in achieving deferral for US persons who are facing outbound. And under the right facts, you guys are in place to offer structures which still provide deferral, which still provide these tax advantage investments for US clients who are in the ultra high net worth space and are looking abroad for tax favorable structuring. So we'll start with opportunities regarding the inbound investor. But first, brief review of some important rules. Now, hopefully everything I'm talking about right now is something you guys are all intimately familiar with. I felt like I had to put it in briefly just to sort of set the table for it. And again, I know this is one of those things where normally people do question and answers afterwards, but please feel free to stop me and interrupt me, to ask me questions. I'm not someone who likes to hear myself talk. I want to be here and be useful for all of you. So we'll go over these rules briefly. Hopefully this is something you're all intimately familiar with. But U.S. income tax residency for U.S. persons is a mechanical test, right? You're either a citizen, you're a green card holder, or you've exceeded a number of days under a substantial presence test which bring you back into U.S. status. And it's an on or off status. It's like being pregnant. You either are or you're not. There's no in between. And so if you pass that substantial presence test, or if you have that green card, or if you have that citizenship, you're taxed on your worldwide income. You're subject to reporting on all your foreign financial assets, as opposed to non-residents who are only taxed on their U.S. sourced income. And even that, the U.S. obviously, some people refer to as the last tax haven in the world, even exempts a lot of that U.S. sourced income from taxation received by non-residents. Contrast that with U.S. given estate tax residency, which is the concept of domicile. That's a subjective test, and the IRS is always going to argue the position that makes them the most money. So domicile is a subjective test. It's physical presence plus the intent to remain indefinitely. There are some exceptions. It's not really relevant towards what we're going on. But the difference between domiciliary and non-domiciliary status is important for foreigners based in the US. And the reason for that is, while US citizens like myself, we have 11.18 million when we die before we're subject to any kind of transfer taxes on death or on estate, foreigners are not so lucky. If you're a non-resident alien, if you're not domiciled here, you get $60,000 against your US situs assets, and then the IRS wins 40%. It's unfair. But it's something that can be structured around. And so a lot of time when we have inbound investors, especially from the LATAM case where there's no real estate tax treaties or anything else to give them the benefit, foreign structuring is really how we get around it. And so I take the example of João, having a Brazilian wife and everything else, and Brazilians being a large part of my practice. So you're setting up an investment account either in the US or outside with US securities, $5 million. The problem is something that, this is a situation I'm sure all of you are familiar with. To the extent he has US stocks, to the extent he has other assets that are considered US situs, he gets $60,000 against the value of those US stocks, and then the IRS wins 40% when he dies. And that's based on value. It's not about gain or anything else, just on your fair market value. And this is something we still use a lot. This is something I've seen even after I transitioned to HSBC 3 weeks ago. We still do a lot of this for our foreign-facing clients. Simple foreign pay. We set it up. Shares of stock in a foreign corporation are never a US situs asset. So this is almost always the easiest way to have any kind of US-based investments in the financial business. You can have $1 billion in the account. It's not a US situs asset. You still get all the exemptions for sales on capital gains not being taxed, portfolio interest not being taxed. And you can basically invest tax-free in the US with US securities on a tax-free basis. I put this in mostly because the 2017 Tax Act changes how this works when you have a foreign client with US kids or other people, US people who are going to inherit. Because it changes to the rules, we used to be able to do something called a check-the-box selection right after that. So if you had US kids and you have a US portfolio, US stocks, if you file that check-the-box selection, which is an entity classification, election, as the IRS says, if you have a foreign entity with certain limitations, you get to choose how you treat this. You get to choose whether to liquidate, you file the classification form with a tax fiction, and get you where you want to go. It used to be that if you filed within 30 days of the date of death, you could magically step up the basis for all the US kids without any kind of tax costs in the US. That changed as part of the 2017 taxes. And by the way, if anyone's interested in the 2016 Tax Act, I've given like 1 hour to our presentations and have slides on all of that. Ask me and I'll send it to you. I'm not going to bore you with details now. So, we changed that structure. This is still using the foreign corporation structure, but when you have the US kids, we now do something like this. When you have those kind of clients who are based in the States or having US securities. And we set up a 3 foreign corporation structure once João and Charles moved to the US. So we have, say, the 1896 set up, and then when he dies, we file that entity classification election on the lower tier company the day before he died, because you file it 75 days retroactive. So we file so it's effective 1 day before death. Everything steps up to 3, and then you file the 2 on top the day after, and you pass the entire portfolio to the non-resident US kid in a tax-free manner. Again, that's basic planning for damage. Again, going to basic planning, we're going to go from basic to more complex. We go back to João. This time he's investing in US real estate. So he buys the apartment building in Miami, it's in his own name for $500,000. He plans to use it as vacation. He dies. So he dies the day after closing. The apartment's still worth $500,000. And again, we go back to that rule. That's $60,000 foreigners only get for the US. He dies the day after closing, he owes $142,000 to the IRS. Doesn't matter if he's held it, doesn't matter if it was in his own name, it was a US situs property, and he passed away. So again, we go back to that structure. And this is something, and it's a little more complicated for US real estate investments, but it generally goes to the same thing. And we go back to the foreign corporate structure. Again, this is a lot of times the most convenient way for non-residents facing English investment. And this actually used to be something I never advised we do. But because of the new tax laws, foreign corporations used to be subject to a tax rate of 35% in the US. Now it's 21%. Pretty close to our capital gains rate. So it works. It's actually a very efficient structure for your clients who are facing inbound US real estate taxes. And we set things up here, a foreign corporation, and it in turn owns the US corporation. And then that US corporation owns, essentially, your US real estate. And through that, you can avoid branch profits tax, you can avoid a lot of different taxes. And there's actually a beautiful tax advantage here, because normally when you have a US corporate structure, foreign corporate structure, there are two levels of taxes that the IRS wants to assert. One is the income tax on the ongoing operations. They want to hit you for every dollar you get there. But then, on the dividend, or the perceived dividend, they want to hit you again for that 20% rate. Through this structure, when you have the foreign clients put up US real estate, if you liquidate that US corporation the same year that you sell the property, you avoid that second level of tax. So foreigners investing in the States, even on the liquidation, they get hit once instead of twice. And this situation can be expanded. We typically do this here, it's the same thing, going still in the simple category of what we do. And this situation can be expanded. We typically do this here, it's the same thing, going still in the simple category of what we do. When you have multiple buildings, for example, we had one client who was foreign facing and he had US kids. And we set up a structure like this where we basically invested through the foreign corporation and we would buy apartment buildings that he then rented out the buildings to different people. This $200 million empire that he basically built through these buildings, equity buildings. And what we did is something similar to this, where he has the different buildings set up in different corporations, that way if he ever sells a building, he can liquidate the company and have the one level of tax. And by the way, I definitely had to keep the slides limited because this is a half-hour presentation, but there are tons of variations on this. And this is actually an efficient structure, even when you have foreign clients who are facing inward with these type of structures, but they have US kids. As long as the company that you set up through this is actively managed, they're running the management themselves, they're hiring their own employees instead of surfing it out to third parties. What happens is, and then this is an example case study where we set it up, you can actually domesticate the structure on death or staple the stock. So the stock is still in the Bahamas, but it's stapled to a US corporation and therefore becomes a US corporation for tax purposes. And you can actually turn it into something called an S corporation, which means that when the US kids inherit, they get a full step up in basis on the shares of the company. They get the one level of tax that goes through the US corporate, for the S corporation shares. And you basically converted what is normally an inefficient structure for US persons into something that they can inherit with a stepped up basis and one level of tax. So, but this is something that's a little bit more interesting in terms of something you can promote to your clients, something you can, if you're looking for clients who are facing inward, and that is the use of portfolio debt. And the IRS has these rules in place that say, normally, obviously if you're coming in on US-IDIS investments, they're fully taxable, they want their pound of flesh, except when you can structure something that's called portfolio exempt debt. And again, because of time restrictions, I didn't really put in a detailed discussion of the approach, but if you meet certain restrictions, they basically wanted to encourage passive investment through income, like lending and everything else, and you get your interest payments back. So you meet these certain restrictions, the interest income that is paid out to the foreigner or to the foreign company is not taxed in the United States. And this can be set up through real estate investments, like we put the example here. The biggest restriction, the most relevant for everything, is restricting the vote. So the people who are investing through this, they can't have 10% or more of the vote. But a lot of the times how we set this structure up, for example, one of the case studies I actually did is I worked with a fund. And we had the fund, and we had something similar to here, where they were basically attaching themselves to a U.S. set of managers who had set up the underlying company, the U.S. corporation, and the buildings that they were buying, managing, and running, and they just basically bought into the foreign field. And they buy into that foreign corporation, but they buy into a combination of debt and equity. And the reason this is important because they structure this so that the debt basically pays out on the interest of the ongoing operations that they're receiving in the rent when the building's empty. So basically what you're receiving is rental income, but structured in a way that it's all tax-free and not taxed in the United States. And it's a fantastic setup when you have clients with these right set of banks who are willing to invest in this. And again, because of the interest of time, I didn't really put in slides on this, but there are variations on this. We had another, actually the same fund, but set through a different way. They didn't actually buy any equity in this. They basically had a similar structure where the US people were running the operations through a structure similar to this, but a little bit different. And they were just providing the lending for the operations. But the lending for those operations, again, comes out completely tax-free as portfolio debt. So it is something else to consider when you have funds who are looking inbound or other people who are looking inbound who can take advantage of these funds. Again, foreign trusts are still great under particular circumstances. They work well, especially for foreign settlers who are doing inbound investments. You can structure them so they're completed gifts, so you're not dealing with that $60,000 limitation. And the benefit of the trust is that there's really one level of tax. And that one level of tax either flows through to be paid by the trust itself or is flowed through to be paid by the foreign settler. And this is another opportunity that still works well for inbound real estate, and works fantastically well when you have that foreign settler with US kids, because you can set things up to basically transition to the next level of efficiency. And it also works for the foreign grantor trust plan, which is another slide I didn't put in, but it's something we can definitely utilize. If you have that foreign grantor trust, you can structure things so that things can exist for the benefit of the children inside that trust, but they're still not taxed to the US child until foreign dad or mom dies. So these still work. We sort of transitioned after 2017 going to the foreign corporate, domestic corporate structure, but this is definitely something you can still use. You go to investment in tiered partnerships. This is something we used to do a lot before the law changed. I put it in basically because it's one of those things that is a change subject to the law. So for those of you who dealt with this, you probably saw a lot of tiered partnership structures prior to 2018. And that's where we set up the foreign entity, and we filed that check the balance selection treated as a flow-through entity for tax purposes. And you basically get all the benefits of one level of taxation, everything kind of flowing through. But the problem is that you only had an argument against that US estate tax, because the situs laws are unclear. So there was still an opportunity that the IRS could come back and say, well, even though you're in a foreign partnership, you're really looking through it, and we want to tax you on the estate taxes if you own those assets directly. But there's also an argument the other way that says, no, what I own is a foreign intangible. A foreign intangible is not subject to tax in the States, which is the estate tax. And therefore, I should be filing a estate tax return, and I should be paying. But again, we moved away from this kind of structure. But it does show that in terms of inbound planning, most of the important things are happening at the foreign level, on the foreign entities that you guys should be setting up. So, I'm probably speeding through this a little faster than I should, but we can go through the opportunities regarding US persons investing abroad. And for this, I actually put in 2 different case studies of things that changed. It used to be under US tax laws that if you had an active business abroad and you were a US person, you had deferral, right? If it was an active business and met certain requirements, and it wasn't subject to certain anti-deferral rules, anything that happened inside that foreign corporation, that active business, was a black box. You weren't taxed in the US on it. So you had this sort of US tax advantage structure, because you could set up active businesses in low tax jurisdictions such as the Bahamas or Barbados or anywhere else. And you'd only have to take those taxes when the dividends are paid out to you. And if you had it in a treaty jurisdiction, then the dividends that were paid out to you were actually at the dividend rates rather than the ordinary income rates, which means that you're taking a one-time 20% tax, which is fantastic for these types of structures. That changed with the 2017 tax law. I won't bore you through it. It's a ridiculously complicated law, which is a huge pain in the ass. But basically what it did is it ended deferral for active businesses. So now if you're a US person and you have active business abroad, you get 10% on the basically basis of your depreciable business assets. After that, you pay taxes on everything current. There's no deferral, and if you want it individually instead of through a US corporation, you don't even really get the foreign tax credits that are underneath them. So you have a situation where you might actually be paying more taxes because it's in that structure. And it's ridiculous. And there was ways you can get around it. I actually spent the first half of 2018 restructuring a lot of clients who had situations. The other thing I wanted to talk about is the elimination of miscellaneous itemized deduction. It used to be that you had this sort of 2% of AGI floor, adjusted gross income, and then you could take those miscellaneous itemized deductions for management fees, for incentive fees, things like that. That went by the wayside for a lot of these situations because of the new taxes. And that presents another opportunity for those of you here who have the right kind of tax, have the right kind of funds, the right kind of compliance. So going back to GILT, right? This is a global intangible low tax income. The US thought it was being really clever that they actually named it GILT. That was their whole point. Gosh, all those people who are stuffing their intangible income offshore, we're going to tax you currently on all of that, punish you for this. And the idea behind it is that what it does is it limits the US corporations, control foreign corporations, to further US income taxing on what they call intangible income. But the problem is this was written in the dead of night. You know, they didn't let anybody see the Tax Act until 3 hours before they passed it. So it was just horribly written. It was just a mess. It's just a total show, I guess, to be the way to say it. So it actually taxes much more than intangible income. It taxes everything. To the extent you don't have depreciable, tangible, personal business property, you are taxed on everything. You get a 10% rate of return on the basis of that depreciable property, not even the fair market value. So once you've started to depreciate those assets, once you've started to deplete them, you are getting taxed on everything on your operations abroad. And unless you restructure or take certain elections, you don't even get the benefit of the tax credits you pay abroad, which is insane. So because of this elimination through deferral, we've had a lot of unhappy clients because the way they're structured, they're all of a sudden getting taxed currently on everything. There's also a repatriation tax that's sort of sidled next to it, so they're being taxed on all their accumulated earnings and profits that existed beforehand. It's not fun. But we can still get around this in certain circumstances. One of the ways that this sort of ties into the case that they're doing is they also created something called a dividends received deductions, participation exemption. So they said, okay, we're going to do this, but we are shifting to this territorial tax system of taxation, which isn't really territorial. But they said, okay, if you have a U.S. corporation on top of these foreign enterprises that you're doing, these foreign businesses, etc., what you can do is the dividends coming out of that U.S. corporation will not be taxed. You have to be a 10% U.S. corporate shareholder. It can't be what's called a passive foreign investment company, which are basically PICs or other, like offshore mutual funds, hedge funds, etc., that don't really qualify as active businesses. And it has to be connected to foreign dividends. It can't be dividends related to investments in the U.S. But going through this, the difference is that the DRD, the dividends received deduction, it only requires 10% U.S. ownership, whereas those guilty rules require that the company be owned or deemed to be owned more than 50% by U.S. persons. So one of the things we did is we took advantage of that disparity, and this goes to an actual case study that we went, is we set up, I worked with a Barbados attorney, who I was actually, before I left, in the process of setting up a cryptocurrency mining company in Barbados. And even though I use Barbados, it's just because this is where I set it up, so this is where the case study was. No reason it can't be in the Bahamas. There's no reason you guys can't utilize the same facts for everything you guys are doing in the right circumstances. But what we did is he set up his active business, and had a warehouse, and had equipment, and had employees. I don't understand the first thing about cryptocurrencies, but I understood what I needed to get to the tax effects. And Barbados taxed them a 1.8% tax rate for Barbados. And then the dividends that went up from Barbados company to the U.S. corporation were tax free. And then when the dividends come out from the U.S. corporation to U.S. investors, they'll be taxed at the dividend rate. So this is tax advantage structure. You have a business operation because we set it up so that the investors could not be 50% in the U.S. We have 40% U.S. investors, out to them 60% owned by foreign people. There's no guilt. There's no anti-deferral rules in place. So what you have is a situation where they have these investors, they can come, they buy in at the U.S. corporate level, and they essentially have tax advantage structure for offshore operations. So to the extent you have, a hotel in Bahamas that you guys are trying to raise capital for, you could build something like this. and offer essentially tax advantage structure in the US. Now, there are securities issues involved. We had a corporate securities attorney who was handling the private placement and everything else. Again, back to securities law, I don't understand how he did what he did, but he was handling that aspect. But you get to a point where if you have these types of facts, you have these types of clients, you have these types of offerings, you could set something like this for a hotel or any other business you have in the Bahamas that needs to raise a lot of capital and offer this to U.S. persons for essentially one of the limited opportunities for tax advantage structure in the U.S. The other case that I wanted to put in was the elimination of the itemized miscellaneous deduction. Right? Prior to the recent tax reform, write-offs for miscellaneous itemized expenses were previously subject to a 2% of adjusted gross income deduction. So because of the Tax Cut and Jobs Act 2018 to 2025, they completely eliminated these write-offs. So if you have investments basically in a passive investment vehicle, which is classified as an investment vehicle rather than a trader vehicle, it flows through the partners of miscellaneous itemized deductions are no longer deductible. So what does this have to do with passive investment? For those of you hopefully familiar with this, PFICs, passive foreign investment companies, any foreign corporation that is 75% more of its gross income is passive, or 50% more of the gross assets producing passive or held for the production of passive. Typically, your offshore hedge funds, your offshore mutual funds, your similarly structured foreign products. And these rules are meant to be punitive. These rules are meant to be no, don't invest in offshore mutual funds if you're a person. Don't invest in offshore hedge funds. Because absent these two different elections, you can take a mark-to-market election and what's called a qualified electing, which is the one we're going to focus on here. Any gains in the disposition of PFIC in excess of an average calculation, essentially, you sell that stock in an offshore mutual fund, everything is called an excess distribution. So if you held that stock for 5 years, we say, you know what, we're going to treat the sale as being incurred over the entire 5-year period. We're going to tax you at the highest rates for those prior years. And then we're going to charge an interest charge. Because if you had sold it in year 1, we would have gotten the income on that. And a lot of times when you hold these PFICs for a number of times, that interest charge, that calculation, basically can become 100% of the sale price. So if you sell something, 100% of the sale price becomes your tax, which is ridiculous. This is meant to be punitive. This is meant to stop people from investing in these foreign funds. And the same thing with dividends. There's an average calculation. It's 125% of the 3 years. To the extent it exceeds that, you go under the same rules. If you held this company for 5 years, that dividend is treated as coming out over 5 different years. Again, highest rate of tax, interest charge from the first day you received it. So it's meant to be punitive. But the IRS threw up a phone when they set this up. And they created something, 2 different elections. This is the one we're going to focus on. QEF, qualified electing fund. And they basically said, well, we'll let the U.S. shareholder at the U.S. shareholder level make this election. And if they make this election, they're basically taxed currently as if this was a partnership. Some modifications, but essentially like a partnership. And they say, well, you take in your portion of the fund's current earnings and profits. Right? So it's long-term capital gain to the extent of their pro rata long-term capital gain. The rest of it's ordinary income. So everything sort of flows through on a net basis in terms of capital gain reported, and then you're not subject to these punitive rules. Right? But because of the way EMP is calculated, all those things that otherwise might be miscellaneous itemized deductions and not deductible under the new law are netted out.
Dividends related to investments in the U.S. But going through this, the difference is that the DRD, dividends versus deduction, it only requires 10% U.S. ownership. Whereas those GILTI rules require that the company be owned or deemed to be owned more than 50% by U.S. persons. So one of the things that we did is we took advantage of that disparity. And this goes to an actual case study that we went, is we set up, I worked with a Barbados attorney, who I was actually, before I left, in the process of setting up a cryptocurrency mining fund in Barbados. And even though I use Barbados, it's just because this is where I set it up, so this is where the case study was. No reason you can't be in the Bahamas. No reason you guys can't utilize the same facts for everything you're doing under my circumstances. But what we did is we set up exactly a business, a warehouse, equipment, an employee. I don't understand personally about cryptocurrencies, but I understood what I needed to do tax effects. And Barbados taxed them a 1.8% tax rate in Barbados. And then the dividends that went up from Barbados from the U.S. corporations are tax-free. And then when the dividends come out from the U.S. corporation to the U.S. investors, they'll be taxed at the dividend rate. So this is tax advantage structure. We have a business operation because we set it up so that the investors could not be 50% in the U.S. We have to 40% US investors, out to them 60% followed by foreign people, there's no guilt. There's no anti-deferral rules in place. So what you have is a situation where they have these investors, they can come, they buy in at the US corporate level, and they essentially have tax advantage structure for offshore operations. So to the extent you have, a hotel in Bahamas that you're trying to raise capital for, you could build something like this and offer essentially tax advantage structure to the US. If there are securities issues involved, we had a corporate securities attorney who was handling the private placement or anything else. Again, securities law, I don't understand how he did what he did, but he was handling that aspect. But you get to a point where if you have these types of facts, you have these types of clients, you have these types of law firms, you could set something like this for a hotel or any other business you have in the Bahamas that needs to raise a lot of capital and offer this to US persons for essentially one of the limited opportunities for tax advantage structures in the US. The other case study I kind of wanted to put in was the elimination of the itemized miscellaneous deductions, right? Prior to recent tax reform, write-offs for miscellaneous itemized expenses and previously subject to a 2% adjusted gross income deduction. So because of the Tax Cut and Jobs Act, 2018 to 2025, we completely eliminated write-offs. So if you have investments in basically in a passive investment vehicle, which is classified as an investment vehicle rather than a trader vehicle, it flows through the partners and miscellaneous itemized deductions are no longer deductible. So what does this have to do with passive investment companies? For those of you hopefully familiar with this, PFICs, passive foreign investment companies, any foreign corporation that is 75% more of its gross income is passive, or 50% more of the gross assets producing passive for helper production passive. Typically, your offshore hedge fund, your offshore mutual fund, your similarly structured foreign products. And these rules are meant to be heated. These rules are meant to be known. Don't invest in offshore mutual funds. Don't invest in offshore hedge funds. Because absent these two different elections, the market election and this called qualified election, which is the one we're going to focus on here, any gains in this position should be in excess of an average calculation. So you sell that stock in an offshore mutual fund, everything is called an excess distribution. So you held that stock for 5 years. We say, we're going to treat the sale as being incurred over the entire 5-year period. We're going to tax you at the highest rate for those prior years. And then we're going to charge an interest. Because if you'd sold it in year 1, we would have gotten the income on that. And a lot of times you would hold these PPs for a number of times. That interest charge, that calculation basis can become 100% of the sale price. So if you sell something, 100% of the sale price becomes your tax. Which is ridiculous. This is meant to stop people from investing in these foreign funds. And the same thing with dividends. There's an average calculation. It's 125% of the 3 years. To the extent it exceeds that, you go under the same rules. You held this company for 5 years, that dividend is treated the company held it for 5 different years. Again, highest rate of tax, interest charge from the first day you receive. So it's meant to be connected. But the IRS was rectified the opponent, and they said it's not. And they created something, 2 different elections. One we're going to focus on, QEF elections, qualified electing fund. And they basically said, well, we'll let the US shareholder at the US shareholder level make this election. And if they make this election, they're basically tax current, as if this is a partnership, some modification, but essentially like a partnership. And they say, well, you take in your portion of the fund's current earnings and profits, right? So it's long-term capital gain to the extent that they're pro-rata of long-term capital gain. The rest of it's ordinary income. So everything sort of flows through on a net basis in terms of capital gain and reported, and then you're not subject to these punitive rules, right? But because of the way it's calculated, all those things that otherwise might be miscellaneous itemized deductions and not deductible under the new law are netted out at the QEF level. So all of that becomes fully deductible again. So I actually work directly with a client who we had this kind of situation where he was ultra high net worth. I was working with CPAs who was preparing the returns that were related to this. But he was actually investing in these funds that had these QEF elections because of what was then the 2% AGI for he couldn't take advantage of. But he could when he had this, and he saw this in tax advantage investment, which is now even more so tax advantage investments now that they're completely eliminating business itemized deductions. So basically going through this, 2018 to 2025, anything that comes out as an investor goes through, no longer deductible by the individual investor, but the offshore entity who set up a QEF, who may be offered, of course again, you have some US security issues that trying to deal with, they can take that on a net basis, fully deducted, which they can look at as tax advantage over some of the offerings in the US.